there is a new photograph of Derek Chauvin, juror number 52. Remember, this trial just wrapped up, and juror number 52, a guy by the name of Brandon Mitchell, went out in front of the media and started giving interviews. And when we covered this last week, we were a little bit curious about what he was saying, because if you recall, a lot of the language that he was using was sort of indicating that he kind of wanted to be on this jury panel. Use some language like, we have to get in there. We have to get on these panels so that we can effectuate an outcome. And he did that, right? He was successful. It sort of reminded me of kind of, elbowing your way into the front of the line or into the front of the room to make sure that you are seated there because you feel like you have an obligation to vote for a particular outcome. That's what his language sounded like. Sounded like, well, this wasn't really a fair and impartial juror, even though during his voir dire, when he was questioned prior to the trial starting, when we were in jury selection, he gave a bunch of answers sort of implying that he had not made his mind up on this thing. Well, now we know he's got photographs of him in BLM shirts and shirts that say, "Take your knee off of my neck." And you're going, how can somebody like that, who is photographed in clothes like that with this particular disposition, how can they truly really be fair and impartial? And this guy got onto the jury and actually was a deciding vote on the conviction. So this is everybody scratching their eyes, scratching their head going, hey, what? This is not right. This is not, a fair and impartial juror here. So we got to break this down. Let's go into it. We're going to start over here from the Washington Post, which is surprising. They're even the Washington Post is going, oh, this doesn't look too good. So it says here, photo of the Chauvin juror wearing BLM t-shirt at the march raises questions of impartiality, experts say. So a photo has surfaced in recent days of a juror in the murder trial of Derek Chauvin. It's prompted questions. Photo shared by several news sites shows Brandon Mitchell, 31-year-old high school basketball coach in Minneapolis, standing next to two relatives wearing a black t-shirt with a picture of Martin Luther King with the words, "Get your knee off our necks," as well as a black baseball cap with the letters BLM for Black Lives Matter. On Monday, Mitchell told the Star Tribune that the photo was posted on social media by his uncle in D.C. last August, during the commemoration of MLK's I Have a Dream speech from 1963. He defended his attendance, saying it was not a march for George Floyd, according to the Star Tribune. All right? And so I am all for people joining causes. I'm all for people participating in the American experiment and voicing their opinions and their dissents and on and on and on. But that's a different question than whether you are a fair and impartial trial when you're sitting in a court of law having sworn an oath that you can be fair and impartial and that you're going to answer questions truthfully, because it sounds like maybe that is not the case here. Yes, we know it was a commemorative speech for MLK. Great. That's awesome. You can go, everybody go and support that. That's a good thing that we're celebrating MLK. But what he was doing was actively advocating for one particular political persuasion, in this case, BLM. How do we know that? Because the hat said BLM on it. And it also, he had a shirt. I think we have the image of it. So it's not a good look and pretty obviously not impartial. All right. The Hill has some more information for us. Chauvin juror on attending the protest, he said, it was a good opportunity to be a part of something. Juror who voted to convict Derek Chauvin is defending his decision to attend a social justice demonstration last year. Brandon Mitchell told the Associated Press, "I'd never been to D.C." Saying that he went to commemorate MLK, says the opportunity to go to D.C., the opportunity to be around thousands and thousands of black people, I just thought it was a good opportunity to be a part of something. During the jury selection process, all jurors were asked two questions as part of a jury selection questionnaire. Number one, did you or someone close to you participate in any of the demonstrations or marches against police brutality that took place in Minneapolis after George Floyd's death, the first asked. Okay? Other than what you have already described above, have you or anyone close to you participated in protests about police use of force or police brutality? Mitchell reportedly answered no to both questions. And if you're somebody who says, okay, well, that's legally accurate, right? He wasn't at a protest, protesting or marching against police brutality. He wasn't for that at all. He was there to honor MLK. And so he answered that question truthfully, because it didn't ask, have you been a part of any civil rights demonstrations? It says, did you or someone close to you participate in any demonstrations or marches against police brutality that took place in Minneapolis after George Floyd's death? No, he didn't. Went to D.C. He was not even in Minneapolis. He was in Washington, D.C. for something that was not against police brutality. It was honoring MLK, right? That's one way to interpret it. The other way to interpret it is this guy knew what the question was getting at, and he explicitly lied. He was doing the lawyerly thing and said, no, I wasn't in D.C. Nope. Or I wasn't in Minneapolis. I was in D.C. No, I wasn't marching against police brutality. I was marching for civil rights. Okay. Right? And that's what lawyers do all the time. It's a legally permissible thing to do. Mitchell separately told Chauvin's attorney during the selection process that he had a very favorable opinion of BLM and that some police officers are great guys. He insisted he could be impartial during the trial. It was directly related to MLK's March on Washington from the 60s. The date of the March on Washington is the date. It was literally called the anniversary of the March on Washington. Mitchell told the Star Tribune in reference to the demonstration he attended last year. So, right, technically, I think he answered the questions correctly. Other than what you already described, have you participated in protest about police use of force or police brutality? So if he characterizes the MLK march, the March on Washington, as something that does not fit within that category, something that is not focused on police use of force or police brutality, then you could say, well, he was answering that question appropriately because it was responsive to the question. The question didn't ask about DC or civil rights. It asked about use of force and police brutality. All right. Well, maybe, yes, but the shirt that you're wearing certainly looks like it's got, get the knee off of my neck. It looks like that you are, in fact, protesting police brutality. So let me take a quick look here. I want to make sure that we have the pictures coming up. So we're going to go through a couple more articles, and then we're going to get to the photographs themselves. The Chauvin juror who attended the pretrial rally may jeopardize the guilty verdict. This was posted on Monday, May 3rd. By Valerie Richardson, said the march was held to commemorate the anniversary of MLK's I Have a Dream speech, but the National Action Network billed it as the Commitment March. Get your knee off our necks. Several members of the Floyd family spoke. Okay, so now we're seeing what this looks like, right? This juror, Brandon Mitchell, may not have, when he was answering the juror questionnaires, may not have considered that to be a march against police brutality because he was characterizing it as an MLK march. But then you look into it a little bit further, it was the Commitment March. Get your knee off our necks. Okay, that sounds like a protest against police brutality, and he was there. And also, the Floyd family spoke. Okay, well, so that gives a little bit of a theme here. Now, it's less about just general civil rights and more about protesting police brutality, which the question was, in fact, asking about. So now you can sort of say, well, maybe, in fact, he was lying. New photos from the event show demonstrators wearing BLM shirts, carrying flags, as well as signs that says, I can't breathe, which Floyd repeatedly told police before he died. The march that he went to, August 28th, was specifically about police brutality. Criminal defense attorney Joe Tamburino, who is not associated with the case, told WCCO. In fact, it was partly advertised as Get your knee off our necks, and it had speakers with the Floyd family, Breonna Taylor, and Jacob Blake, which are, of course, all three victims of police brutality, of police incidents, however you want to characterize that. Breonna Taylor was shot and killed by police. Jacob Blake was shot, not killed by police. And George Floyd was, died at the hands of law enforcement. So they were all there, all speaking. Everybody knew what this was about. It wasn't just a civil rights march. It was more about police brutality. So what does that say about this juror? Did he lie on the questionnaire? March on Washington. George Floyd family urges protesters to be his legacy. All right. So here we have this one now posted over from the Washington Times, August 28th, 2020. And so this is back on that day, right? What is the 2020 March on Washington? Thousands of people gathered back in 1963 to do this. And this says called the Commitment to March, the Commitment March. Get your knee off of our necks. A reference to the death of George Floyd, who died in May. Sister of George Floyd, whose death in police custody sparked months of racial turmoil across the U.S., urged civil rights protesters to be his legacy. My brother cannot be a voice today, she said. We have to be that voice. We have to be the change. Floyd was one of several relatives of Black Americans harmed or killed. Speakers demanded racial justice at the event. So we know what the event was about. This juror knew what the event was about. He was wearing a shirt that had the name of the event on his body, which we're going to see here shortly. Jillian over on Twitter says, was there a BLM plant in the Derek Chauvin jury? Brandon Mitchell, juror number 52 in the Chauvin case, was seen last summer, way before being summoned for jury duty, wearing a "Get Your Knee Off Our Neck" shirt with a BLM hat. Here is the juror. Is this a video? Let's see. Well, I guess that's not a video. So here he was on Good Morning America, back when we covered this previously. But a lot of the language that he was using was about, I wanted to get on the jury panel. I felt like I had an obligation to be there, and that other Black Americans, if you recall, the news anchor, who I believe was also African American, asked him something about that. Why is it so important that Black men are on juries? And, the regular question, or the regular, I think, sort of response would be, well, because we want a jury of our peers, right? That's what our justice system prescribes. It says you can be convicted based on a jury of your peers. And so if we have African-American defendants, of course we want some African-American people on the jury, so we have a racially diverse group, something that is representative of society, something that reflects society's demographics on the jury panel. Therefore, we have a cross-section of our peers. Don't want to go back to the 1940s where you'd have an African-American defendant commit some crime and a bunch of white jurors just say, well, that guy's Black, therefore we should convict him. Right? That was wrong then. Same type of concept is wrong. Jurors are supposed to follow the law, follow the rules, and apply the law to the facts that they observed in a trial. You don't want it to be about, getting onto a jury panel and then making sure that you get the particular outcome that you want in the name of social justice. And so this gentleman, Brandon Mitchell, when he was on Good Morning America with that news anchor, she asked him, why is it so important to get on there? And he didn't say, well, because we want to be representative. He said, well, in other words, we've got some things that we want to see happen in this country. We want some particular outcomes. And so we need to get on there so that we can have a voice, so that we can have a say. And the analysis, or the analogy I was asking you last week, ask yourself, does this man sound like a fair and impartial juror, or somebody who is close to an advocate, somebody who has a cause, a position that they want to see reality? They have an outcome that is desirable to them, and they're going to do what it takes to get that achieved. And this is what, essentially what it looks like Brandon Mitchell did, which is kind of bizarre. This person doing this might literally result in a new trial for Derek Chauvin. I'm going to show you the motion that Eric Nelson and their attorneys submitted today, about 30 minutes ago. So here is the picture that everybody is sort of talking about. This is the next generation being socially active, representing in D.C. my son Marzell, nephew Brandon Renee Mitchell, tagged, and brother with some hearts over here. So we've got, this is him, right? He's decked out. Get your knee off our necks, BLM. You see the two BLM fists here being raised up. We see an image of MLK. All right. Okay, we have BLM hat at the top here. And so he is just fully decked out in BLM gear. He's got it all. And he was somebody who was seated on the jury. Now, if you are not following attorney Andrew Branca over at Legal Insurrection or on Parler or on Twitter, I would encourage you to do that. Does great work, did an excellent job on the Derek Chauvin case. And he posted back on March 15th, day 6 of the jury selection. It's called voir dire. And so if we go back to his post, we can see what the process looked like for juror number 52, for Brandon Mitchell. So let's take a quick look and just do a recap. Then I want to show you the motion that was submitted this afternoon on behalf of Derek Chauvin regarding post-conviction motions and sort of asking for a new trial, because it's looking more and more likely now. If another juror comes out, oh gosh. All right. So this came over from Andrew Branca, and this, you'll notice, March 15th, right? So what are we talking about? This is when the 9th juror was seated. Okay, 3 others were said that we cannot be fair and impartial. They were excused. But on day 6, during voir dire, juror number 52 is seated. He's a youngish male. Obviously, the jurors are not being shown on camera. I had to speculate. I would guess that he was Black. Got that right. Was described as working in the banking industry, customer focus. Nothing much remarkable about the voir dire of number 2. That's the questions. He professed that he'd be willing to be fair to both sides. Judge the case only on the evidence and law presented in the court, even if he thought the law was wrong or should be changed, and that he could provide the defendant with a fair and impartial hearing, which is exactly the buzz phrase, right? That's exactly what you want the jury to say. Now, we all know that in August of last year, he was doing something totally outside of the the tone of this, he was doing something where he was not impartial. He was an advocate for a cause. And again, I'm not saying that there's anything wrong with that. I support that. I am an advocate for a lot of things here on this show. I'm not upset about that one bit. What I am upset about is that he is so biased, obviously one-sidedly, that he then sort of manipulates the questionnaire on the during voir dire, during jury selection. And this whole thing now might come back to bite this movement in the butt if he does in fact get a new trial. So Nelson said, you wrote, I don't believe Chauvin intended to murder anybody, but having seen the video, don't know what reasoning would be. Can you listen to what people say about police training and police practice with an open mind as to what the reasoning could be? Juror number 52 said, yes, I'd like to know what the thought process would be. He also wrote in his questionnaire that he wondered why other officers had not intervened. When pressed by the defense to explore what this meant, he assumed that Chauvin acted wrongfully, indicated not necessarily so. He compared it to if he were driving somewhat thoughtlessly and a passenger prompted him to pay more attention. Someone can intervene even if what they are doing is not done with malice. So we have another question here. Nelson says, your impression of Officer Chauvin, did you form the opinion that he was doing something wrong? 52 says, I don't know that he did something wrong, but somebody did die. Even if no intention's doing something, somebody could have intervened and prevented that. I'm not paying attention and driving my car. So let's see what else. Prosecution passed for cause, so they wanted 52 on there. Number 52 became the 8th juror, and he said here, we can look at this from an objective point of view. And so we'll see where this goes. I want to show you this motion that has been submitted today. I want to show you this. We'll read through it here briefly. This was submitted at 3:59 p.m. So filed in Minnesota just this afternoon, May 4th, filed in district court, same court that we have been following along so far. It's defendant's notice of motions and post-verdict motions. All right, so now we know, let's frame this out a little bit. Trials ended, okay, trial was concluded, conviction on all 3 counts for Derek Chauvin. We saw him put in handcuffs and hauled out of court that day. He's not scheduled for sentencing, I believe, until early June, maybe June 5th. Already been some transport orders. They're going to bring him back from custody and bring him in front of sentencing, where the judge is going to determine what length of time he goes away for. And here now, we have something sort of in between those two things. We have the conclusion of the trial, sentencing is coming up, but they're already asking for new trials and wanting to make some pretty significant motions. So let's go through this. Here we have motions. Number 1, they want the following relief. What's the first thing they're asking for? An order granting a new trial. They're going to Minnesota law. They're saying that the interest of justice are proper grounds for this. Also, the abuse of discretion that deprived the defendant of a fair trial. They're also saying prosecutorial and jury misconduct, errors of law at trial, and a verdict that is contrary to the law. Well, that's a lot, right? The specific basis for this motion includes that the court denied the motion for a change of venue, saying that, well, this should have been a fair and impartial trial. A different venue would have supported that. The judge did not grant that, and the court abused its discretion as a result. They're also saying the court abused its discretion when it denied the motion for a new trial on the grounds that, quote, publicity during the proceedings threatened the fairness of the trial. Such publicity included post-testimony, but pre-deliberation intimidation of the defense expert's witness, from which the jury was not insulated. Not only did such acts escalate the potential for prejudice in these proceedings, they may result in a far-fetching chilling effect on the defendant's ability to procure expert witnesses, especially in high-profile cases such as Chauvin's and co-defendants. The publicity here was so pervasive and so prejudicial before and during this trial that it had amounted to a structural defect in the proceedings. And we saw this, right? Now, I don't recall the timeline on this, but we did see that I think there was a pig's head and pig's blood smeared across the house of somebody's residence. It was supposed to be one of the defense expert witnesses. I think officer, sergeant, whatever, Brode, I think was the witness. And somebody found his old address, went to his house and smeared a bunch of blood all over his door. So, whoever the neighbors were, or whoever actually owned that home, they had a bad morning when they went out to get the newspaper. But the point here is the judge did not move venue, did not sort of protect some of that stuff from happening. And the public opinion in the court of public opinion, there was so much volatility, so much anger and animosity that the question now becomes, will that spill over into the trial? Will that go and impact your expert witnesses? Will it impact your lawyers? Okay, we saw this back during the election litigation of 2020 when Donald Trump was trying to get a bunch of different law firms to help him out with his election litigation. Many of those attorneys were just sort of bailing, abandoning ship. They didn't want to work under the pressure. Same type of concept here. What if the public is so one-sided that expert witnesses just say, well, listen, I have an opinion on this thing, but it's just not worth it because somebody's going to come to my house. We know that there was another Derek Chauvin expert witness. I think it was Fowler, who is also, being sued. And so there's repercussions coming from the people who did step up and advocate on behalf of Derek Chauvin. And in the future, maybe people just don't want to do that. And then the defendant is really at a serious disadvantage just in terms of the availability of resources to help them win their case. This complaint goes on, and I wanted to show you this. Let's talk briefly about, we're going to get to the order here in a minute, I think. Okay, so here, let's go back to the motion. The court abused its discretion when it failed to sequester the jury for the duration of the trial, or at the least admonish them to avoid all media, which resulted in jury exposure to prejudicial publicity regarding the trial, as well as jury intimidation and potential fear of retribution amongst jurors. And we know this, right? Because we saw that the Dante Wright shooting happened right around the corner from where all this happened. There were protests taking place. One juror who turned out to be the alternate was traveling back and forth between the courthouse and Brooklyn Center where the protests were happening. So she was seeing a lot of this stuff. Same with other jurors. We had Maxine Waters, who flew in there, parachuted in from California to come and throw a bunch of stones at other people's houses. And the list kind of goes on, right? CNN, all the news people were there. Everybody was bracing for impact before the jury panel was even, before the jury was even sent to the deliberation room. All of this was unfolding for about 3 weeks during the entire trial. Judge didn't do much about it. Didn't even really warn them. City settled for $27 million. Maxine Waters came out and basically made verbal threats. If there's not a particular outcome, then she's going to be advocating for essentially violence. And you're going, what? Judge didn't even call people back up for voir dire. Didn't even ask them questions if they heard it. Says, oh, I already admonished them. And look, Cahill's got to do that at this point, right? Because the trial is over. What's he going to do? Say, well, all right, we just did this whole thing for nothing. We're going to do it again? It's tough. Rock in a hard place on this one. State committed pervasive, prejudicial prosecutorial misconduct, which deprived Chauvin of his constitutional rights to due process and a fair trial, but not limited to disparaging the defense. Remember, we saw that at the end when Blackwell was saying things like, they're telling you a story, right? Their fictional story or their narrative or whatever they want you to believe. He's sort of belittling their interpretation of the events. And Eric Nelson brought that up at the end, and it sounds like the judge admonished him and reminded him not to do that. They had improper vouching, and they have also failing to adequately prepare its witnesses. Court abused its discretion, violated Chauvin's rights under the confrontation clause when Maurice Hall didn't testify, or in the alternative, none of his testimony got admitted into evidence, right? So under the Constitution, you have a right to confront your accusers. And if people are accusing you of things, you have a right to present evidence to defend yourself. And so now we've got this really, really tricky commingling of rights. You've got Maurice Hall and his right to remain silent. You've got Derek Chauvin and his confrontational right, his ability to go and confront the people who are accusing him of a crime or who are involved in the accusations against him. Maurice Hall was in the car, could have been very, very closely related to the causation that actually killed George Floyd. We know that Maurice Hall historically had provided drugs to George and his girlfriend, and maybe he could testify about what George did. Did he ingest a couple of those pills that were right there in the front seat dashboard or what? But he didn't testify, did he? We also have this complaint saying that the court abused its discretion when it submitted jury instructions to the jury that failed to accurately reflect the law. The court abused its discretion in violation of Chauvin's constitutional rights to due process when it permitted the state to present cumulative evidence with respect to the use of force. So that means just bringing up expert after expert after expert. We had a lot of them all talking use of force. We had the chief of police. We had the LAPD sergeant. We had, I think, 3 or 4 people use of force. And I don't remember if Eric Nelson was objecting to this stuff, that it was cumulative. But, in law, you can't just say the same thing over and over 25 times. That's not a good argument. That is duplicative. It's too repetitive. And eventually people go, all right, right? And there's something that happens psychologically. I think during World War II, there was Goebbels, right? Somebody said, hey, if you tell a lie long enough, eventually people will believe it. It's like if you keep hearing the same thing over and over and over again, eventually you go, okay, that has to be it. And so that's what they're saying happened here. It was, in particular with the use of force, same evidence presented a bunch of different ways. The court abused its discretion, violated Chauvin's rights when it ordered the state to lead witnesses on direct examination. So that's just a questioning style. I'm not real sure how much I heard that or saw that stay out. Leading questions is sort of asking questions that guide a witness to the next point. So you can say, isn't it true that on March 1st you were here, right? And isn't it true after that date you moved over here? And isn't it also true that when you walked in you spoke to Mary, and it's also true that Mary said so-and-so about so-and-so, correct? Yes, and right. So you're asking them questions, but you're leading them through to the answer that you want, which is much more different than sort of an open-ended question, which is what you should have on direct examination. During a direct examination, you should say, okay, so tell me what happened on March 1st. They go off into the narrative. Well, I woke up, I had breakfast, I got my kids ready for school, went through the whole thing. And so, okay, what happened after that? You're not leading them. You're giving them the opportunity to fill in the blanks, versus on a cross-examination, then you are leading them, right? You don't want them to give you those big, long-winded answers. You want to say, so it's true, right? Yes. Again, they go, yes, but nope. Yes or no, right? And you narrow them down. Okay, so they're saying that this line of questioning or this type of questioning was allowed, even though it's impermissible. The court abused its discretion in violation of Chauvin's constitutional rights when it failed to order that a record be made of numerous sidebars that occurred during the trial. We saw that happen a lot. Cumulative effect of these multiple errors deprived him of a fair and impartial trial. An order for a hearing, so they want an order for a hearing to impeach the verdict on the grounds that the jury committed misconduct, felt threatened or intimidated, felt race-based pressure during the proceedings, and or failed to adhere to instructions. They also want an order granting the defense additional time to thoroughly brief the issues above in light of the time that was required for the preparation of partial transcripts of the proceedings. Any other relief. The motion is based upon files and records in this case presented here by, there he is, Eric Nelson, attorney for the defendant from Halberg Criminal Defense. So yeah, it sounds like right now they're preparing transcripts, right? Very long trial. They're going to beef all of those up. Eric Nelson's going to review them. What we just saw was sort of a notice letting the court know that there's more coming on this thing. We're just giving you notice that these are being filed, and they're going to ask for 60 days, 90 days, or the court. There's probably a rule in the Minnesota statutes that say, well, okay, we're gonna have arguments on this case in 90 days. Government, please brief your response to these motions. We'll see where it goes. So interesting, very, very interesting, and we're going to see if other jurors start trickling out. I mean, can you imagine if this whole thing has to start over again? Oh no. Pato in the house. Oh, let's take some questions over from watchingthewatchers.locals.com. Pato's in the house. Says, hey, Robert, love the show. It's looking more and more like this juror had an agenda and even lied to get on the panel. What at this point can be done besides the appeal process? Could the judge reject the verdict and declare a mistrial? Could Mr. Marshall be charged with perjury? I think that all of those things are possible, right? I think that, yes, the judge could. We saw what Nelson was asking for. I'm not sure. It's hard for me to speak on some of the specifics on this because I don't honestly do appeal or post-conviction work in Arizona. And certainly I don't do it in Minnesota, but I know the nuts and bolts of it. But, each one of these things sounds like it is a reasonable outcome, right? The judge, as we saw in Minnesota, they called it impeaching the verdict, which would be going back and saying, this whole thing's tainted because a juror wasn't impartial and a juror did lie on a voir dire questionnaire. Now, if they're going to, so here's sort of the problem with this perjury question. The people who charge people with crimes are the prosecutors. Okay, the prosecutors in this case have a favorable juror who helped them get the verdict that they want. So is the prosecution going to now go and charge Brandon Mitchell with a crime? the juror that gave them the outcome that they wanted. Do you think that that's going to happen? I certainly don't. Robert, have you ever experienced jury misconduct? Are there criminal or civil penalties that apply in those instances? So they're typically admonishments. You know, you heard some of that during the Chauvin trial. I have never had jury misconduct. I can't even think of anybody in our firm that has, to the degree that it warrants something. I mean, there's always, you know, little problems here and there. Somebody's late, somebody's on their phone, somebody's not paying attention. It's sort of, you know, the kids are misbehaving in class type of gripes, not something that is, you know, that warrants a new trial or a post-conviction relief motion or anything like that, that I have personally seen. And we don't even get many calls about it. I mean, honestly, you know, people will call us about appeals, but nothing about jury misconduct. You know, it's always about something went wrong in trial that a lawyer did or that the prosecution did, but appeal cases almost never come in based on jury misconduct, in my experience. So not something that is particularly common. Besamiento says, can and should the juror be charged with perjury? He knowingly lied to the court under oath. You know, that's a discretionary call, right? You can make arguments both ways. You could take the crux of the question that was asked on the questionnaire, and you know, I think you can make a good argument that he didn't think that what he was involved in applied. Now, I think that is total BS, but I'm talking about this from a defense attorney, right? We all know what he did. He knows what he did. He even admitted it because he was on with Good Morning America telling the other woman about this. So, yeah, we got to do more of this, essentially. And so, you know, that is clear. But the prosecution, as I mentioned with the last question, they're the people who get to make that charging decision, and they're very happy with the outcome that he gave them. So, you know, there's another situation where this comes up a lot. In a domestic violence case, what often happens is it's a man and a woman get into an altercation. Police are called. They show up at the apartment. Guess who goes to jail? Want to take a stab at it? Yeah, it's the guy. Every time, 99 out of 100 times, the guy gets arrested. He gets, you know, brought into custody. All right, he gets charged with disorderly conduct, domestic violence, assault, domestic conduct, whatever, right? Even if she started it, doesn't matter. He gets charged. We go into court. We now set the case for trial. Case is ready for trial. Okay, this couple has, let's say, reconciled. The other party wants nothing to do with the case. They don't want, you know, they were angry the cops came to begin with. They didn't call, the neighbor called. Okay, nobody wants the police to show up at the situation. So let's say the female, who is the, quote, victim in this case, doesn't show up to court. Government doesn't have a key witness because their victim is not there. Nobody else was there. Neighbors didn't hear the fight. Neighbors didn't see anything. Police didn't see anything. They came after the fact. The whole thing was over by the time they got there. But when they show up, they got to arrest somebody. So somebody goes away. We get ready for trial. The victim doesn't come to court. What happens? She got a court order to be there. She's not there. Government doesn't have their witness. What do? They got to dismiss the case. They can't proceed without their witness. Cops didn't see anything. Neighbor didn't see anything. Defense isn't going to get up there and testify. So they have to dismiss the case. But what if the prosecution is really angry now that the victim didn't show up? That's their key witness. They didn't come to court today. So the next question then logically is sort of like what happened here with this juror. Does the prosecution that needed that victim to show up, do they charge her with a crime for violating a court order and not coming to court? 99 out of 100 times, no. Typically, no, unless it's a serious felony case, unless it's something that warrants that type of a response. But it's the same concept here, right? The prosecution in my victim case, they do not want to punish the victim. She's already been the victim of a crime, allegedly, so they don't want to add insult to injury, right? This guy, same type of situation, already on a jury, already, you know, did his civic duty, whatever, sat through a 3-week trial, made it on there, gave the prosecutors the verdict that they wanted. Do you think that they're going to charge him with a crime? No, of course not. We have no doubt, says Tim Poole said that the Floyd family spoke at the event he attended. Even with that, is this likely enough for the judicial system to reverse itself? So I think it's absolutely worth taking a very, very good look at this through the Court of Appeals. It's too early to speak on this quite yet. I would like to read the full brief that Eric Nelson's obviously going to be preparing. But yes, you know, these types of things, in my opinion, are persuasive. They are powerful because it's obvious that you had somebody on the panel who was not fair and impartial. And the evidence is just, it's overwhelming, and it's It's not good. NY Renal MD says, I despise what Chauvin did. However, if the judge doesn't declare a mistrial, I feel a fair trial is a distant memory. The spirit of those questions is that we don't stack the jury with activists. Yeah, it's not about that, right? And you know, this is not an uncommon question. We talk about this in the law in the form of jury nullification. Okay, you can Google that, and you'll see that is a legal concept. This is a thing that people talk about. Now, judges won't let you do it, and you can't do it in the courts because they will flip because it's not allowed sort of in the court of law. But this is still something that people do. People will say, well, I don't like that law. It's called jury nullification. The prosecution hates this concept, but you could have the government present their entire case. Let's put this in the context of marijuana. Okay, let's say that you have a 12-person jury, and 3 of those people are ardent advocates of marijuana. They use it, plant-based medicine. They think it's great. Defendants is now being charged with a marijuana crime because in this jurisdiction, marijuana is illegal. So you might have those 3 jurors on there who use marijuana regularly. They're not happy that this law exists. They're not happy that this defendant is being charged with this crime because they think that the drug war is insanity and that prohibition doesn't make any sense. Okay, so that's fine. That's their personal opinion. They're free to think that. But if they try to impose that political disposition in the jury deliberation room, that's a huge problem. That's called jury nullification. They're not asked to apply the law as they deem fit or ask whether the law should be in existence or not. That's the purview of the state legislature and of our elected officials. It's not the purview of the jurors. The jurors are supposed to get in there, listen to the facts of the case, apply the law as written, regardless of your political ideology or whatever your opinions are on the case, and then come to a conclusion in that manner. So if you have, in this marijuana example, you have these 3 jurors who just say, oh, it's too bad, right? I think marijuana laws are stupid. And so we're going to vote for an acquittal here. Well, and on that basis, and that came out, the judge might order a new trial. Same thing, same type of thing here, right? The witness here, the juror here is somebody who is clearly biased in one direction. And we now know that. It's troubling. Liberty or Death says, here is a question. If by some long shot Cahill declares a mistrial or the appeals court remands, do you think the prosecutor would put him on trial again? Yes, I do. I think they would have to, and the change of venue would happen, but everyone knows what has happened at this point. Yeah, I totally agree with you, Liberty, on that one. I think that I'm not so sure that Cahill's going to get involved. If I had to guess, I'd say Cahill's just going to do as much as he can to send this upstairs. He did, I think, a great job running the trial to the best of his ability. Disagree with a lot of his decisions, but he was sort of dealing with an impossible situation. So I think he ran it the way that he ran it. He's going to send it upstairs. We'll see what the Court of Appeals does. I'm very excited to see what the government says in response. This is going to be interesting because this is sort of kind of a case of first impression. We've had very, very important, popular national cases in this country before, but this one sort of had the entire media and most of the elected government officials all in alignment rowing one direction. And when that happens and you have a conviction on all counts and then you have some juror malfeasance or at least some improprieties happening here, maybe this works its way up to the Supreme Court and they tell us how to deal with this stuff because this is going to happen again. We got Kim Potter's case. We've got a lot of other ones that are going to be coming down the pike, no question. Next up, we've got HLB says defendants get innocent until proven guilty, right? Supposed to. So does the jury not get assumed to only have facts of the case in mind unless proven to be an unbiased plant based off of the actions and words while being a juror? Wait, does anyone oversee juror deliberations or possible past connections to assure no planted jurors? Boom, more American jobs. So HLB has a stimulus plan here. Boom, more American jobs for juror deliberation overseeing, which is, so kind of yes and no, right? There are other people there who are, helping facilitate the deliberations. But no, there's nobody in there like a judge or a bailiff, guiding the deliberations because we don't want the system involved in the deliberations. We want the jurors to deliberate. We don't want a judge to walk in there and tell the jurors how to deliberate because they'll just defer to the judge, And we don't want that. We want the jurors to decide. We have Anki Woe says, given the BLM juror, it now makes an even more difficult challenge to get an impartial jury, because even if there is one juror secretly sympathetic to BLM, that juror would be able to comprise the identity of any disagreeing juror post-verdict and bring the destructive mob to the person's homework and destroy their life. Ooh, that's a good point, right? Yeah, you sort of get somebody on the inside, and that somebody on the inside can communicate who the rest of the makeup, who the rest of the jury is, so that external pressure can come to bear on them. Yikes. I don't know what that does to the justice system, but doesn't look good. All right, we've got last one in the house. NY Renal MD says, how about the judge charging him with contempt of court? In that case, it can be outside of the AG's office, right? Yeah, so the judge, yeah, that's a good point. I think the judge could charge him with contempt, hold him in contempt, and penalize him that way. I think the judge could do that. It's a good point. I didn't think about that one, but that's a good point. All right, good questions. All of those came over from watchingthewatchers.locals.com. Thank you so much for your support. Really appreciate it when you go over there and help us kind of keep things on the track over there. It's a great community. Ask questions. Download a free copy of my book. Get promo codes for everything. Download it's good stuff. watchingthewatchers.locals.com.